All right, I think we're set now. All right, we'll be on the record in Butte County case CR 12-19-639, State of Idaho versus Amanda Katherine Steele. Ms. Steele is appearing by video. She is represented by Mr. Shane Reichert, who's also appearing by video. State is represented by Butte County Prosecuting Attorney Steve Stevens, also appearing by video. We're set for a change of plea. The court has reviewed the plea agreement and has reviewed the guilty plea advisory form and the amended information. Counsel, I've got some concerns. The amended information indicates felony injury to child and gives the felony penalties, but the charging language doesn't match the felony requirement. It doesn't allege a felony offense, as the act must be under circumstances or conditions likely to produce great bodily harm or death, and that's not indicated in the information. I also have some concerns about that as well, because where it's not in the information, I'm not sure if your client's going to be able to allocate to a factual basis for that requirement. Mr. Stevens?
Yes, let me pull up the statute, Your Honor. Yeah, I guess the state just respectfully disagrees with the court that that language is not right out of the statute and does have felony implications with that punishment, right, in subsection 1 of 1501.
I'm not sure I followed your argument there.
Your Honor, I can read subsection 1, injury to child statute, to the court. The language that's in the information is right, is right from the statute. Having the care or custody of any child willfully causes or permits the person or health of such child to be injured is a direct quote from the statute and in subsection 1.
Let me see where I had this information at.
Judge, sorry to interrupt, but is there any way that you could either make me a co-host or press the record button on the bottom? Thank you.
Let's see.
And I understand what subsection 2 says, but subsection 1 also has the same language and the same punishment.
Well, hang on for just a minute, because I had this last week when I was going through this. Now I can't find it.
Your Honor, I guess to save us some time here as well.
Hang on. Because the other thing I had done is pulled up the jury. Oh, no wonder I'm on the wrong instruction. I was reading the misdemeanor injury to child jury instruction. The jury instruction for felony injury to child. In order for the defendant to be guilty of a felony injury to child, the state must prove each of the following: on or about the date in the state of Idaho, the name of the defendant, had the care or custody of the child, who was a child under 18 years of age, and the defendant willfully caused or permitted the child's person or health to be injured, or the child to be placed in such a situation that the child's person or health was endangered, and the above occurred under circumstances or conditions likely to produce great bodily harm or death to the child.
That's exactly what subsection 2 says.
Right. So that's the thing, is that it doesn't, your information doesn't allege circumstances likely to produce great bodily harm or death. Right?
I think that's a fair interpretation, Your Honor. Subsection 1, the first paragraph of 1501, blends all of that language together and then gives the misdemeanor and felony punishment together. And then subsection 2, I think, is probably an attempt to clarify that, but I don't think it's ever been adjudicated one way or another. But again, I think that the court's point that they're probably the factual allocution or the factual basis for the plea is going to be difficult for the likely to produce great bodily harm or death standard for felony injury to child. Unless the court is willing to assume that a sex offense, the factual basis for a sex offense would satisfy that standard.
Not without some sort of evidence, and the amended information doesn't include that language as it is now.
Well, Your Honor, and we can certainly amend that to have that. I don't think that's going to get us past the factual allocution issue if the court doesn't see those facts as likely to produce great bodily harm.
Mr. Reichert?
Sorry, Judge. Yeah, I think our intention was that very line of reasoning that Mr. Stevens is discussing, is that the factual basis, the intimate relationship, we don't know what it did cause, so to speak, with the bodily harm, but we know that it could cause great bodily harm. We also know that it can cause the mental suffering as well. So our position is that—
Well, it doesn't refer to mental suffering. It says produces great bodily harm unless you get some evidence that shows that the child, that this occurred under circumstances likely to produce great bodily harm, and you've got some evidence that you're going to rely upon to show that. I'm not going to be able to accept a plea on that.
Well, the great bodily harm would be it could cause. Isn't that correct? Isn't that what the language says? And so
what is it? What could cause? What's the harm that it could have caused? And what are you relying upon? I'm not going to accept a plea on some fiction.
Well, and if that's the court's position, I guess we'll just have to go back to the drawing board.
Well, that's why I raise it right now before we go through all this, is that I've got some concerns about being able to take a plea unless there's a factual basis for it.
Well, again,
if you can get some evidence that shows that these types of circumstances would produce great bodily harm, then I can be there. But you're going to have to give me that evidence and what you're relying upon.
Well, couldn't great bodily harm be any potential injury that a child could have long term? I mean, what's that definition? I don't remember it off the top of my head. Maybe the court does. But sexual relationships with a minor child could produce great bodily harm. Obviously, I mean,
Okay, and if I take that as the premise, what are you relying upon? And that's what I'm getting at. You've got to give me some evidence that this conduct could produce great bodily harm. You get that, and you're good.
Well, the part of it is just the plea negotiations in of itself. I guess the other option would have been potentially an Alford plea or something something of that nature. I guess I just haven't run into this issue. I've done this on multiple occasions, and I understand not before Your Honor, and so I just haven't dealt with this issue with respect to kind of circumventing the factual allegations that are alleged versus the plea agreement that's in place, with my client understanding and knowing that she's accepting responsibility for a felony offense that is an injury to child, that her acts could have produced it. And I can't point to any specific piece of evidence, Judge.
Well, that's the thing. When I ask an individual to make an allocution, and it's got to be to every element, and you're going to have to tell me what's the harm that could have happened, and what are you relying upon to get to that harm. We're not just going to make it up.
Well, it might. Well, sadly, I think that happens on numerous occasions every single day. Maybe not recently due to the lack of hearings, but I think facts and parties agree to allege facts or non-alleged facts all the time to get deals done. In this case, the certain minor victim, who's no longer minor, I think is minors, is now alleging some mental suffering that's to me would be considered great bodily harm, whether it's PTSD or whether he was, I don't know that I recall anything physical injury, but I think PTSD could be considered a great bodily harm.
And do we know that individual suffers from PTSD?
Judge, I think it was just alleged, or there was discussions of it, that he was having some emotional issues in that regard. I don't know if there was a formal diagnosis. Maybe Mr. Stevens could expand on that.
Your Honor, I'm afraid not. I think that Your Honor, the state's position is that the court's analysis is correct on this. This is the result of negotiations and compromise. I guess if the court were to see it in the vein of an Alford plea, where the parties, the plea agreement actually has the defendant waiving the right to appeal the conviction. So when the parties are agreed, they're just proposing a solution to this case, Your Honor.
I understand that, but I also have an obligation that not to just make things up. I have an obligation to make sure that it's done properly and that the plea is based on factual circumstances.
And I think that's fair, Your Honor. I don't think that there's going to be any way that the parties are going to produce. I don't think the state could produce facts that could satisfy the elements of this if it was contested. And I think that's all we can do is present this as a possible resolution. If the court's analysis doesn't allow the court to accept a plea under this or this Rule 11 plea agreement, I guess procedurally, Your Honor, if the court denied the motion to dismiss and amend, then we'll be right back where we are, and the court can just set this matter for trial. It really, Your Honor, the court has to approve this. So I don't think the state has any argument that's going to change that analysis. I think that analysis is correct. I think the parties were relying on the court seeing the parties not contesting the allegations as a way of accepting a plea. And if the court doesn't see that as lawful, then this resolution is not going to work. So,
Mr. Reichert?
Judge, I don't think we're going to be able to produce any evidence of great bodily harm. As Mr. Stevens alluded to, this is just part of plea negotiations that there's a lot of.
Can you get me some research that shows that PTSD
Well,
is
I don't.
the equivalent of great bodily harm, and that these circumstances could produce PTSD.
Well, Judge, I don't. Based on what Mr. Stevens just said, I don't. I thought it was referred to in police reports for that. It sounds like there's been no formal diagnosis, and maybe that was just something that was off the cuff in one of the reports.
All right.
I don't think there's any evidence of that at this point, Your Honor. You know, what we can do, Your Honor, though, is if the court does deny the motion today and set this for trial, the parties are going to continue to negotiate. And understanding better what the court's position is on how we can resolve this case, we will continue to negotiate. And I think the parties are looking at a resolution that reflects all of the underlying circumstances that are enumerated in the state's motion. But obviously, if we can't perform an allocution that the court sees lawful, then we're going to go back to the drawing board, as defense counsel said, and we will continue to negotiate. But
let me ask you this. You know what my concern is, at least on that regard. The rest of the plea agreement, I wouldn't make any type of judgment on until after I see a PSI and a psychosexual evaluation. And so, Ms. Steele, so you understand the process, once I'm able to accept a plea, we would set it for sentencing. I would order the psychosexual evaluation and the PSI. And then once I get that information, then I'll come back to court and say, okay, I've reviewed this information. I've heard from your attorney and the state's attorney, and I can accept the plea agreement and be bound by it. Or I would tell you, no, I can't accept the plea agreement and be bound by it. And typically I tell you what my concerns are. And then if I reject the plea agreement, you would then have two options. You could either maintain your plea with the understanding that the sentence that I impose could be harsher than that contemplated by the plea agreement, or you would be allowed to withdraw your plea. Typically in that circumstance too, if I tell you that I'm not going to accept it, I'll give you some time to consult with your attorney and figure out what you want to do. I won't make you make that decision right on the spot. But I got to get over this first hurdle first to figure out how I can even accept the plea on a factual basis. So here's my suggestion. If you're available on the 30th, we'll have a hearing. And is what I'd like you to do is see if there's cases out there, some other information that would allow me to accept a plea where under these types of circumstances, there could be great bodily harm, or that PTSD or some type of emotional harm is the equivalent of great bodily harm. And I'll do some research as well, come back and figure out where we're at on that basis on the 30th. And if we can't figure it out at that point, then I'll give you a trial date and you can continue to work on the case. Mr. Reichert?
Judge, that works. If I recall correctly, I thought there was some case law that allows for these types of scenarios too, not just with the great bodily harm, but through plea negotiations. So I'll check on that as well.
Yeah, if you can get me that, I'm not aware of it, but if you can get it to me and I can rely upon it, great, we'll go forward.
Thank you, Judge.
But the information, or at least the amended information, will have to be amended as well to make sure that we have all the elements. Mr. Stevens, does that work for you?
it does, Your Honor. Thank you.
Are you both available on the 30th then?
I think so.
Ms. Steele, are you available?
I believe I am. Yes, I am, Your Honor.
All right. Mr. Reichert,
Works for me, Judge.
morning or afternoon?
Either one, no preference.
Mr. Stevens,
Either is fine with me, Your Honor.
9:30?
That works fine for the state, Your Honor.
Ms. Steele,
Yes, that works for me, Your Honor.
Mr. Reichert?
Yes, Judge.
All right, we'll go ahead and set this. It'll be by Zoom again. The clerk will send out the invitation and then I'll do some more research on this, figure out where we're at. We'll come back and talk about it. So we'll reset this for September 30th at 9:30 a.m. for status conference. Anything else in this matter, Mr. Stevens?
No, Your Honor, thank you.
Mr. Reichert?
No, Your Honor, thank you.
Ms. Steele, well, counsel and Ms. Steele, I just want you to understand, I'm just trying to make sure that we do it right. I'm not trying to throw a wrench into the negotiations because it sounds like you've all worked on it very hard. So, but I want to make sure we do it right. Okay.
Thanks, Judge.
All right. You're excused, Mr. Reichert, Ms. Steele. Thank you.
Thank you.